Good morning. This is the State Court of Clayton County. I'm Judge Tammy Long Hayward. This is the jail and arraignment calendar for August 5th of 2025. I'm going to call the calendar we just have the jail calendar today. First case on the calendar is Melanie Calderon.
Judge, Ms. Calderon, today we are going to enter a negotiated plea. We're going to ask that the court take that under first offender, and that's the announcement.
All right. So first offender for Ms. Calderon. All right. Next is Dana Maurice Dodson.
Your Honor, my client is looking to resolve this matter. We have not received an offer from the state. I don't know if the state can announce their offer.
Your Honor, I'll meet the defense down in the courtroom and I'll make sure they have a copy of the offer immediately.
Okay, thank you.
Thank you.
Elizabeth Masceter.
Judge, I did conference with Ms. Masceter, and I believe we're going to resolve that case through a plea today. I do need to go over the finer details of that with Mr. Tipton, but I think we're going to try to resolve that through a plea today.
All right, so we've already modified Ms. Pope's sentence. Why is it still on the calendar?
Just looking at the calendar, Your Honor, it says motion to modify sentence. So I believe, I don't know, the system thinks that we need to be heard on the motion. You already signed the order and she's been released on her FDA. So
okay, so she's out. All right, Devon Lathan Thomas. This is an SSD.
It appears that he paid in full, Judge, and was released.
All right, that's a good thing. Sorry it took until he got arrested to pay his fines and fees. Ladies and gentlemen, please pay your fines and fees if you have a suspended sentence and you've been given time to pay. Please pay your fines and fees. You don't want to be on the end of finding out, as Mr. Thomas was. All right, Nikos Isaac Thomas.
Your Honor, my understanding is that Mr. Thomas hired a private attorney and he's out on bond.
Okay. Do we know who that attorney is?
No.
Karen Pass. It was either Karen Pass or I'm not 100%, but I think it may have been Karen Pass.
They haven't filed entry, Your Honor,
So, Mr. Walker, Mr. Middleton, Miss Val, did Mr. Middleton, is he appearing or did he give us a?
I'm here.
Oh, there you are, Mr. Middleton. I'm sorry.
Oh, I'm Mr. Thomas.
No, I'm looking for Mr. Middleton, the attorney.
He had a conflict, Judge, and we excused him from appearing and reset this case, Mr. Walker case to.
Okay, did he sent a conflict letter in?
Yes.
Okay. Because the reason I'm asking is because this is, okay, I'm hearing somebody's feedback. This is a motion to revoke bond, which means that he's allegedly done something that would cause the court to consider revoking his bond.
Correct.
And every time we reset, he was out still.
Exactly.
Okay, so when do we have him set for?
We kind of talked about it yesterday, but you just tell me, we can always move it. It is a motion to revoke. We scheduled him to come in today, and then he said he had a conflict.
You're asked for set for, I think that we've already reset it to be accommodating for him twice. I think 1 week is enough time.
Yeah, next Tuesday, no resets.
Okay, I'll make sure it's on next Tuesday.
All right, thank you. Okay, Mr. Thomas, is this Mr. Nikos Thomas?
Yes.
All right, so my understanding is, sir, you've hired a private attorney?
Yeah, Karen Pass.
All right, so is Ms. Pass available today or what's going on?
I have no idea. I got a letter in the mail yesterday that it said I had court on the September 15th.
All right,
so I didn't know.
We'll see you on September 15th with Ms. Pass.
Okay.
All right, thank you.
Thank you.
All right, Taj Wedlo. Mr. Austin said he's gonna be on. He had to do something this morning, but he's gonna be on for Wedlo.
Yes, Judge, and I believe perhaps it may be appropriate for Mr. Austin and perhaps Mr. Tipton to do a conference about what may be recommended or what they may be willing to recommend, just to see whether you would be inclined to go along with that, or if you had any thoughts on that, Judge.
Okay, you want Mr. Tipton to talk to Mr. Austin to see if I'm gonna be amenable to what is gonna be recommended.
Essentially, Judge, just I thought based on what we had discussed and what I discussed with Mr. Wedlow, that he may want to accept what the probation office recommend, but in light of sort of the procedure here, I thought that it may be appropriate to ask whether you would be willing to accept that.
Well, I mean, why don't we just do what we normally do and have the discussion?
Sure, Judge, we're fine with that as well.
Okay, Paul Leonard Williams.
Your Honor, my understanding is that the accusation was filed past the statute of limitations. We filed a plea and bar yesterday, and defense is ready to move forward on that plea and bar. I would like for the state, if they can proffer what evidence they have as they allege in the accusations, that Mr. Williams concealed himself and then they invoked Jones versus State. And if state's not ready for the plea and bar today, Your Honor, we would like to be heard on bond, as my client is being held without bond on the family violence charge.
All right, Mr. Tipton.
Your Honor, state is not prepared at this time to respond to the plea and bar. State would request a reset for the plea and bar and has no objection to having the bond issue heard today.
All right, so let's talk about bond now. Let's go ahead and do that now. We'll set the plea and bar for next week.
On the 12th, Your Honor?
Yeah.
Should Mr. Williams come out, Your Honor?
Yes.
Can you please?
Judge, I'm going to set Attorney Middleton case to the 19th instead of the 12th, because that's a trial week. And we don't, what you want to do? I just
Well,
know
I
that's
would
the trial
prefer
week.
to set Middleton's case sooner because we've moved it twice.
Okay,
And then if we're gonna do the plea and bar, then we can set that one on the 19th.
okay, that's good.
Yeah, so I would switch them.
Okay,
Your Honor, so the plea and bar is set for August 19th?
Yeah. But we're talking bond now.
Yes, Your Honor. Your Honor, this is Mr. Paul Williams before you.
All right, Mr. Williams, you're before the court. You're charged with case 2025 CR 06888. Paul Leonard Williams, State versus Paul Leonard Williams. You're represented by Attorney Tortorello, who's with you at the podium. You're before the court for driving on a suspended or revoked license, count 1. No license, count 2. Battery, family violence, count 3. Battery, count 4. Simple battery, family violence, count 5. Simple battery, count 6. And obstruction of a telephone call, count 7. Ms. Tortorello, you're filing a plea and bar regarding the accusation that has been filed in this case. Is that correct?
Yes, Your Honor, it was filed yesterday.
And is it as to all counts listed?
Yes, Your Honor.
All right. So, Mr. Williams, the plea in bar, which means Ms. Tortorello is asking that the court prevent the state from going forward with the prosecution for the reason that she believes that the accusation was filed past the statute of limitations. So we will hear that on August 19th, but it is my understanding that you are in jail, being held without bond, which is not common for misdemeanors. So we will consider bond today. Okay. All right. So Mr. Tipton, Mr. Barbarello, are you all ready to be heard on bond?
Defense is
Your,
ready.
Your Honor, I'm just reviewing his criminal history. It'll take me a moment longer.
No problem, sir. We'll start in a moment. Ms. Tortorello, do you know if he was without bond due to 1710-1? Was it probation or parole or previous conviction for a violent misdemeanor or felony?
Let me get a clarification, Your Honor. Your Honor, it may be that my client was in probation when he was charged with the battery family violence. But it's under your discretion, Your Honor, under the statute to consider bond, especially given the fact that if the court can take judicial notice that the accusation was filed in the state court clerk's office on July 20, 2025. 7 counts alleged that the incident occurred on June 4th of 2023. Therefore, the state had until June 4th of 2025 to file this matter, this accusation. So just taking that into account, Your Honor, and I don't know if I should start with the Ayola factors.
Yes, please.
My client, Your Honor, is not a flight risk. He has 5 children here living in Georgia, specifically in Riverdale and Forest Park. He has relatives that live in Rex, Georgia. He doesn't have a job at the moment, Your Honor, but he is going to focus on finding himself a job while he's out on bond through the internet or a job placement company organization. He will live with Taylor Williams, his daughter, in Riverdale if he's out on bond. He's not a danger to the community, Your Honor. He's committed, he has no offenses on his record, but for robbery by force back in 2005 out of Bibb County, and no violation of probations because of this matter, Your Honor. So
I'm sorry, Ms. Tortorello, you cut out. No, what outside of Bibb County?
I said that he has no violent offenses on his record, but for robbery by force that was back in 2005 out of Bibb County. And then I said no violations of probation because of this case.
Okay.
Yes, Your Honor.
Just,
And
how old is he?
he's 58 years old, Your Honor.
All right. And who was the alleged victim in the case?
It was his wife, Your Honor. Let me look at the name here. Rosalind Morse.
Mhm.
That's the alleged victim, and he's on counts these charges for 44 days, Your Honor.
Okay. Is he still married or is it an ex?
There is no proof that they are divorced, Your Honor. So my understanding is that they are still together. They're married. Their marriage is intact.
Okay. All right, I'm ready for you when you are ready, Mr. Tipton.
Yes, Your Honor. Your Honor, going through the Ayala factors, I do believe that Mr. Williams is a flight risk. On the night of the incident, he vacated the location prior to the police getting there. Further, Your Honor, he does have some additional violent crimes in his history. That includes, yes, the robbery from 2005. That was let's see, he has that robbery. He also has a simple battery out of Bibb County, which was from 2000. He
Um,
was
Objection, if the state could please read whether or not there were actual convictions while you're
they
reading.
are. These are convictions, Your Honor. I'm not going through any of his other 29 cycles regarding whether or not if they are not convictions, then I will not bring them up, and I'm only bringing up the violent offenses.
Okay.
And Your Honor, further, Your Honor, he had not had any contact with law enforcement until a recent criminal damage in the second degree that's pending. That's been indicted out of Bibb County. So, Your Honor, I think he has plenty of ties to Bibb County. I don't think he has very many ties to Clayton County. I also have concerns regarding his history and regarding the facts of this case, in that it appears that Mr. Williams did take flight from the scene before the officers arrived. So, Your Honor, I would request family violence $1,000 and a bond no less than $10,000 on the obstructing telephone calls, and a bond of no less than $3,000 on the driving while license suspended.
All right, Ms. Tortorello.
Your Honor, as far as my client taking flight on the day of the incident, as Your Honor has heard from the state, he stated it appears that the state's not even for certain if that was the case. Just because my client wasn't at the scene when the cops arrived does not mean he fled from the scene to avoid law enforcement. As far as no ties to Clayton, Your Honor, I've already stated, Your Honor, he has children that live in Clayton County, and he is going to live with his daughter who lives out of. Huh? Hold on a second. His daughter, Taylor Williams, who lives in Riverdale, Your Honor, which is in this jurisdiction. And as far if Your Honor can provide him with a reasonable bond for the battery family violence so that he may bond out on a charge that is against my client on an accusation that was untimely filed due to the statute of limitations. Nothing.
What you asking for, counsel?
$2,000, Your Honor. Especially given the circumstances that he's in right now.
What was he arrested on? Not what he was accused of, but what was he arrested on?
Your Honor, he was most recently arrested in Bibb County for a criminal damage.
No, this arrest. What was he? So he has 7 charges. So I'm just trying to figure out, like with the jail, am I supposed to give a bond for all 7 or only the ones he was arrested on?
Only the ones, Your Honor. He was arrested on driving while license suspended, obstructing a telephone call, and battery family violence.
Okay, so he'll have $1,000 on license suspended and obstructing a call. So that's $2,000 total. And then on the battery family violence, he'll have a $3,000 bond. So it's $5,000 total.
Thank you, Your Honor.
All right, thank you. All right, and also the bond conditions will require him to stay away from Ms. Morse, the alleged victim in this case, and not to have any other violations of the laws of the state of Georgia.
Thank you, Your Honor.
All right, thank you. All right, so we have Calderon, Dodson, Masceter, and Wedlo. We're waiting on Mr. Austin for Wedlo unless I thought Mr. Carmichael. Mr. Carmichael, are you doing Wedlo?
Good morning, Your Honor. Yes, I am. I'll be subbing in for Mr. Austin till he gets back.
Okay, no problem. And then Dodson, I guess y'all were still speaking about.
Yes, Judge.
Mr. Tipton, you said you were going to go down to the courtroom.
Yes, Your Honor. I'll go down now. For
Y'all
that.
do that and let me know when you're ready. Unless we're ready to go on Wedlo. If we're going to go on Wedlo, we can do that now before you walk down.
Judge, if I may, I would like a few more minutes on Wedlow.
Okay, that's fine.
If you wanted to go ahead and do Calderon, just go ahead and get that out of the way.
Oh, that's fine if y'all are ready. Okay, bring up Calderon.
And Your Honor, I do see someone who's on the Zoom call as just an iPhone. Would it be possible for us to determine who that is?
Sure. Who's on as iPhone?
Yes, it's Lennis Ponder.
I'm sorry, Miss Ponder.
Yes, ma'am.
What's
Your
your
Honor,
first-
she's the complainant in the new case against Mr. Wedlo.
Oh, okay. What's your first name, Miss Ponder?
It's Lennis, Lennyce.
Your Honor, if at some point I may have a moment where I may speak with Miss Ponder, I would be grateful for that.
Okay, so this is what we'll do. We'll take Calderon. I'll give you a breakout room to speak with Miss Ponder. Once you're done with the breakout room, you can go down to the courtroom.
Thank you, Your Honor.
All right, thank you. All right, whenever Calderon is ready.
She's on the way. Okay, so whatever charges the bond or to reflect that those bonds are modified by the amounts just set. Okay. Other bonds, you know, those charges are. If the other bonds are not being changed, then you don't need to address them. It's probably not going to it doesn't change any bonds, then that needs to. Yeah, it needs to be specifically say like, yes. I'll try to explain it. It's good to stand right here, Ms. Calderon.
All right. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true? All right. So Melanie Calderon, you're before the court on 2025 CR 06979, State of Georgia versus Melanie Calderon. You're before the court for battery, family violence, count 1, battery, count 2, simple battery, family violence, count 3, simple battery, count 4, cruelty to a cruelty witness. I've never seen that before.
I believe it's supposed to be cruelty to children in the 3rd degree, Judge.
Okay, I've never seen it written like this before. Cruelty to children in the 3rd degree counts 5, 6, and 7. And number 8, criminal trespass with damage to property. All right, Ms. Calderon, your attorney has asked that we take this plea under the first offender statute. I'm sure he has informed you about your first offender statute rights and responsibilities, that this is a one-time deal. You won't have this opportunity anymore. And if you successfully complete, this will have benefits with respect to how this is reported or not reported on your criminal record. If you fail to complete it properly, then it's going to show up as a guilty, and you'll have whatever repercussions come with that. Do you understand? Speak up for me. All right. So Mr. Lynch, what is your client plea to the offenses before the court?
Judge, it's going to be a guilty plea to count 1, and I believe this counts 5, 6, 7, and 8. We're asking that those be taken, that this plea is taken under the First Offender Act.
All right, is this okay with the state?
One moment, Your Honor. Let me just confirm that she's eligible. Yes, Your Honor. State has no objection.
All right. I enter in a plea of guilty to counts 1, 5, 6, 7, and 8. Counts 2, 3, and 4 will merge. You give up the right under first offender. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. On June 26th of 2025, officers with the Clayton County Police Department responded to 1246 Stoneham, that's Stoneham, one word, court in Atlanta, Georgia, in a portion of Atlanta that is within the boundaries of Clayton County. There they made contact with with Miss Alani, Alani Gandera, Gandera, and her sisters Nayeli, Nayeli, and Melanie, Melanie, as well as another lady, Miss Melanie Castro, spelled the same way as Melanie's name, last name Castro. It was determined that the defendant before you, Miss Calderon, did inflict visible bodily harm on Miss Melanie Castro by striking her in the face with a closed fist, causing a red swollen mark on her face. They were married at the time, Your Honor. This did occur in front of 3 children that were under the age of 18, those being
You just give me the ages.
Yes, those being children that were 14, 9, and 10. And during the tussle, the defendant before you did punch 2 holes into the wall of the shared property. The victim is here and wishes to make a statement. Would Your Honor like to hear that prior to the state's recommendation or after the state?
Go ahead, I can hear it.
Okay, Miss Melanie, if you would unmute yourself and raise your right hand, please. Please raise your right hand, ma'am. Do you swear or affirm any testimony you give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please lower your hand, ma'am. Please state your name for the record.
Melanie Castro.
Okay, Miss Castro. How are you related to the case of State of Georgia versus Miss Melanie Calderon?
She's my wife.
Okay. And you've spoken to our office through Miss Hemphill, is that correct?
Yes.
And you wanted to make a statement today, is that correct?
Correct.
Go ahead and let us know what you want to let us know, ma'am.
Okay. All I wanted to let y'all know is that yes, this is her first offense, and do what y'all will with that. All I ask is that she does have my property, which is my cell phone, if she can retrieve that back to me and not fight me on this annulment, because we do have an appointment to get annulled sometime next month, and that she does not fight me on that. And that's all I request from her.
So you can make the request, ma'am, but we deal with the criminal matters. I can't make her not fight you for an annulment. I can request that she give back your cell phone, and set a time limit and set penalties for that. But I can't make her not fight an annulment or a divorce. So,
Okay, that's fine.
uh,
As long as I get the phone back. Yes, ma'am.
so, anything else?
No, ma'am.
Does she have any like personal property there that needs to be returned?
She does have my cell phone. That's all I asked.
No,
The
I'm talking
damages.
about, does she have any personal property that's still in your location?
Oh, no, ma'am. I'm not residing over there anymore. I literally moved states because of the incidents.
Okay. All right. Mr. Lynch? Oh, I'm sorry, recommendation?
Yes, Your Honor. With regard to count one, it's going to be 12 months to serve 35 days, balance probated. Family Violence Intervention Program, 40 hours of community service, $300 fine, no contact with the victim. Counts 2, 3, 4, and 5. I'm sorry, counts 2, 3, and 4 will merge into count one. Counts 5, 6, 7 will be 12 months served, 35 days concurrent with count one. Count 8, the only request that we made on that was restitution. That will be a of the cell phone for property.
Judge.
Mm-hmm.
If I might just have one moment to verify something with my client that I want to get a little clarification on.
Excuse me, Judge. I didn't
Yes.
hear the restitution part for
I
count
think it
8.
was just return of the cell phone, but I might have to fill that in a little bit.
Thank you.
Uh-huh.
So, Judge, I just wanted to verify, we understand that the sentence recommendation is no contact with the alleged victim who we just heard from. The incident location, though, that's not a do not return. She
said she moved 2 states away, so
the victim,
I don't know that that's a problem.
her stuff is still at the incident location. I believe that that is where she continues to reside. Is that or
Are you listening to me, Mr. Lynch? Am I muted? Because I just said she testified that she has moved 2 states away and she's no longer at that location. So the location is really not in play.
No, you didn't move 2 states away. My client did not move away. My client's still residing.
Melanie Castro moved 2 states away.
I understand that. I'm just trying to clarify.
She is not in the location.
Yeah, I understand that.
That's why I had to clarify if there was anything there that was still there. And she said, no, I have moved 2 states away.
Okay.
All right. So I don't care about Miss Calderon going back to that location.
Thank you, Judge. That's all I was.
That's why I ask these questions, Mr. Lynch.
I understand, Judge. Sometimes
All right. So, Ms. Calderon.
No.
So I don't understand how people expect relationships to work when there's violence. I really don't. I just don't understand how being violent in a relationship is supposed to work. Being violent in a relationship means that you really don't want the relationship, because the relationship is supposed to be the safe space for all parties involved. Once you work through that door, everything that's going on in the outside world, all of the stresses, all of the issues, those are supposed to be left on the outside. And if you're having issues with the person that you're in a relationship with, then you need to get counseling to figure out how best to communicate, because there's always going to be some stressors. There's always going to be job issues, financial issues, personality issues, all of those things. But I don't understand how anybody thinks a relationship is supposed to work when you're violent. Mrs. Castro is saying, don't fight me on the annulment. Well, y'all are married, so it might not be an annulment. It may be a divorce. For some reason, some people think annulment is when they just get tired and we were only married a short time. That's not necessarily the case. So it might actually be a divorce. But that's neither here nor there. The issue is I don't understand wanting to, I understand Miss Castro's point of view, because who wants to be in a relationship where there's violence? And what she's saying is, I'm done. I'm walking away. I'm done. Too many times we see people say, I'm done. I'm walking away. And then the other person reacts in a violent manner. What I'm saying to you is, are you the person that anybody would want to be in a relationship with? If you are not, then work on that, because we can only change ourselves. Whether somebody wants to be with us or not be with us, we can only change ourselves. And if violence is in a relationship is what you think is going to work, I can tell you it will not. You got me?
Yes, ma'am.
And no kids need to see that. No kids need to see their parents being violent. No kids need to grow up in a situation where they're not sure when the next plate is going to be thrown or what's going to happen next. Nobody needs to see that. And so for whatever your next relationship is, because Ms. Castro says she's done, and she has the right to be. People have the right to choose to not live in a situation where there's a lack of communication and there's violence. Whatever your next relationship is, I would suggest that you do some work before you get into it. Now, you're going to be taking the Family Violence Intervention Program. It is a 24-week course. Take it seriously. There's a lot of helpful techniques in there to avoid this kind of thing happening again. But I just don't understand when people say, oh, but I love this person, and then there's violence. Because how can you love and be violent at the same time? Those are not two things that go together. So I'm going to accept your plea under the first offender statute for count 1, 12 months to serve 35 days. Is she getting credit for time served, or is she continuing to serve?
Judge, I believe that's.
Your Honor, that will be credit for time served.
Okay. Credit for time served. The balance will be probated for you to take the Family Violence Intervention Program. If you miss more than 3 days in a row, they're going to make you start all over again. So please be mindful of that. Fine in the amount of $300. That's going to be $444 with the surcharges. And you're to have no contact with Alani Gandara, with Melanie Castro, with Nayeli, and I missed one baby's name. What is the baby's name, Mr. Tipton?
Excuse me, Judge. I'm the mother.
Yes, Ms. Castro.
No, I'm not Miss Castro. I am the mother of the children.
What? I'm sorry, I'm so confused now. Who's the mother of the children?
I am the mother of the children. Hold on, I'm trying to.
Uribe?
Yes, ma'am.
Okay, so how? All right, so Miss Melanie Castro and Miss Melanie Calderon. Miss Melanie Castro is your child also?
Children, the 14-year-old, the 9-year-old, and the 10-year-old. Miss Melanie Castro and Miss Melanie Calderon, both were living with me at the time of the incident.
All right, hold on. Can you turn your video on?
Yeah, that's what I'm trying to. There we go. Okay. I'm sorry.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Okay, you can put your hand out. Are any of them living with you now?
No. So they were living with me when the incident happened. I was not at home. I came home to the incident. My children were the one that were at home when it happened.
Okay, does Miss Melanie Calderon need to have any contact with your children?
So I requested, I don't mind. Miss Melanie Calderon is family. She is my cousin. She is the one who was living with me when they got married. Melanie Castro moved in with me. I don't mind still having contact with Melanie Calderon. I don't mind my kids still having contact with her. I did let her know, though, she, unfortunately, because of the situation and the everything that happened and how my kids are feeling about the situation now, she can no longer live with me. But she can come over, grab whatever's left there. She has a little bit of clothes there left. I don't hold no grudge against her. My kids, like I said, they are kind of a little traumatized, scared of the situation because I'm a single mother of 3, and that's one thing I don't do is, like you said, family violence relationship.
Okay,
I,
hold on, Mr. Dominguez. Okay, so first thing, grown people need to have their own space. And so I'm not sure how the Melanies got to living with you. I'm sure you were being very kind to them, but grown people, especially people who grown enough to get married, they've grown enough to have their own space. So that's you. I'm gonna order that there be no violent or harassing contact with any of the children, the 14-year-old, the 9-year-old, and the 10-year-old. With Miss Melanie Calderon. If you want to have her around your children, that's up to you. But she's to have no contact with Miss Melanie Castro, except for any contact ordered through the court system to affect the annulment or divorce or whatever court process is going on. Ms. Calderon, unless it's ordered by the court that you communicate certain things, information through the courts, you're to have no contact. Now, let me explain what no contact means so we don't get off on the wrong foot. No contact means you're not to call her, text her, have a third party call her, talk to her through your cousin, do anything on social media, call her job, call any of her relatives. Don't have any contact to the whatever you would think of as contact, any contact, and then think of more, no contact. Because if you were to have contact with her, you would be in violation of my sentence. If you violate my sentence, you could be returned to jail and spend the remainder of the 12 months in jail. You could also be charged with additional misdemeanors or felonies. The felony particularly of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or both. So you are to have no contact with Melanie Castro, except as required for you all to be divorced or annulled. All right. So count to run concurrent with that for 5, 6, 7, and 8, which will run concurrent with count 1, 12 months to serve 35 days. Credit for time served balance will be probated. On count 8, you're to return the cell phone to the sheriff's office of Clayton County by August 10th. If that cell phone is not returned, you run the risk of being in contempt of this court and this court's sentence, and also being returned to jail. Do you understand? I'm sorry, you're gonna have to speak up. All right. So I got a yes, ma'am out of that. So Ms. Calderon, like I said, love doesn't hurt. So anytime you are in a relationship, if you're the one doing the hurting, you need to check on yourself and get some help with communication, because that's not how relationships go. Okay. All right. You can go back with the sheriff's office. All right. I'm going to give Mr. Tipton the opportunity to speak with the witness in the case. Mr. Tipton, who's that witness again?
Your Honor, that'll be Miss Lennis Ponder.
Okay,
I also think that let's see. I think I saw Mr. Thought I saw the victim in the previous case come on, but I think he may have left.
Okay, I see somebody who has a Motorola, but I don't know who that is. So
Cedric Wedlo, Your Honor, that's the other person. I wanted to speak with him at some point. If I may be put in a breakout room with one of those two and Miss Hemphill, I would appreciate it.
all right, I'm putting you in breakout room number 2. Number 1, I'm sorry. Everybody should get the invitation now.
Thank you, Your Honor. Also, I did provide Mr. Lynch with the recommendation via electronic means for Miss Dodson. I'm not sure if he
we
was.
are, Mr. Dodson, I have gone over that rec with him and advised him of his rights. He is ready to enter a negotiated plea. If you want to go ahead and do that, we can do that.
Any concerns with Mr. Dodson today?
Judge, I've spoken to Mr. Dodson. He's doing great. He has been
good.
for a while. He does have a plan of a place to go. So I don't have those concerns despite the court's history with Mr. Dodson.
All right, thank you. All right, so Mr. Tipton, once you come out of the breakout room, then you can walk down to the courtroom and let me know when y'all are ready.
Yes, Your Honor. Thank you.
Well, I was hoping that would happen, but it looks like they already did the breakout room, so, and I'm not muted.
Your Honor, the deputy has brought out Mr. Dodson and he's ready for his plea. I'm not sure if we could, I understand Mr. Tipton's in the breakout room.
Ms. Tortorella, who's gonna take the plea if Mr. Tipton is in a breakout room?
I understand that. I'm just announcing that he's before you, Your Honor.
All right, I see him. Mr. Dodson, how you doing today?
All right, doing okay.
All right, I'm gonna be right back, okay? Just give me a minute to get Mr. Tipton back into the courtroom, okay?
Hello? Hello? Excuse me. Jesus Christ.
Sir, please mute until the judge returns. Just mute your device until Judge Hayward comes back on.
Okay.
All right, is Mr. Tipton back? Mr. Tipton? Think he's still in the, well, no, Miss Lenise is out.
Yeah, he's not in the courtroom, Your Honor, and I don't see him on the call, on the
Okay.
Zoom call.
Good morning, Your Honor. I will follow up with Mr. Tipton and make sure that he gets back on.
All right, is there anyone who needs a Spanish interpreter? Ms. Tolles is on, and I don't want to hold her so she can go to another courtroom if she's needed.
Yes, ma'am. Looks like he's on now. Thank you.
Thank you. Mr. Tipton, Ms. Tortorello, does anyone know of anyone who may need a Spanish interpreter?
Defense does not need the interpreter services, Your Honor.
Okay. Ms. Tolles, we already spoke with Ms. Calderon.
Yes,
and in
ma'am.
that case, and everybody spoke English. They're fine.
All right, thank you.
Thank you, ma'am. Take care.
Take care.
All right, Mr. Tipton, did you need anything else before we go on with Mr. Dodson's case?
No, Your Honor. I was just speaking with the victim still on the on the Wedlo case.
Okay. So can we take Mr. Dodson's, please, so we can get
Yes, Your
him
Honor.
sent back? All right. So, Mr. Dodson, raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. Thank you, Mr. Dodson. You can put your hand down. You're before the court of Dana Maurice Dodson, 2025 CR 00263 for criminal trespass. Ms. Tortorello is your attorney. Ms. Tortorello, what is your client plea to the offense before the court of criminal trespass?
That would be a guilty plea, Your Honor.
All right, by entering a plea of guilty, Mr. Dodson, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, sir. Yes, ma'am.
All right. Factual basis, Mr. Tipton, and recommendation.
Yes, Your Honor. Your Honor, on December 28th of 2024, the defendant before you, Mr. Dodson, was at the Hartsfield-Jackson International Airport after being given notice to not return to the Hartsfield-Jackson International Airport without business at the airport. He was at the airport requesting food from the patrons of the airport. State's recommendation, Your Honor, is 12 months to serve 225 days, credit for time served, balance suspended upon do not return to the airport, and no new violations of criminal law.
All right. Ms. Tortorello?
Your Honor, only that you accept the plea as negotiated. And further, Your Honor, Mr. Dodson does have a place to stay once he is released.
All right. So, Mr. Dodson, I'm going to accept your plea of guilty, sentence you to 12 months to serve 225 days, credit for time served, balance suspended as long as you do not go back to the Hartsfield-Jackson Atlanta International Airport.
Yes, ma'am.
All right, sir. I hope, Mr. Dodson, I wish you well. I hope you stay on your plan, okay?
Okay.
All right, thank you.
Thank you, Your Honor.
All right, Masceter and Wedlo are the last two cases. What are we ready for?
Your Honor, state would request to go back in the breakout room with Ms. Ponder if Masceter is not ready for the plea.
All right, Ms. Ponder is on twice because she's in the breakout room and she's also she's in the courtroom.
Yes, Your Honor. I'll go back to the breakout room. Thank you.
All right, thank you. All right, we'll be waiting for Mr. Tipton.
Your Honor, since I have you online, I did send you and Mr. Tipton a copy of, the bond order for Mr. Williams
Okay,
via email.
all right, so I'll let Mr. Tipton look at it and then I'll look at it.
Mr. Lynch, I'm back in my office. I'm ready for that plea when you're ready.
All right, we're ready. If we can go forward with the Masceter plea and then do the hearing on Mr. Wedlo, if that pleases the court or whatever the court's choice is.
The court is ready.
Okay,
So whatever y'all put before me, I got it.
we're gonna bring out Ms. Masceter, Judge. You're gonna stand right next to me, Ms. Masceter.
All right, ma'am, raise your right hand for me.
She's attempting it. Yeah, there you go.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
Yes, sir.
Okay,
Yes,
you
ma'am.
can put your hand down. Ready?
Yes.
Okay, so you, Ms. Masceter, you're before the court on 2025 CR 04397, Elizabeth Masceter for battery family violence count 1, battery count 2, simple battery family violence count 3, and simple battery count 4. Your attorney is Mr. Olin Lynch, who's with you. Mr. Lynch, what is your client plea to the offense before the court?
Judge, she's gonna enter a guilty plea to count 1.
All right, by entering a plea of guilty to count 1, counts 2, 3, and 4 will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. Give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Yes, ma'am.
All right, thank you. Factual basis and recommendation, please.
Yes, Your Honor.
Mr. Tipton, I can't hear you.
Yes, Your Honor. On March 29th of 2025, officers with the Clayton County Police Department responded to 7852 Terra Road in Jonesboro, here in Clayton County. There they made contact with the victim in this case, PCIA Masceter, and that is spelled the same way as the defendant's last name. It was determined that the defendant before you, Miss Elizabeth Masceter, did inflict visible bodily harm to Mr. Masceter by pushing him, causing a large cut on his arm. Your Honor, the state's recommendation is 12 months to serve 129 days, credit for time served, balance suspended upon no new violations of the criminal law, and no violent or harassing contact with the victim, Mr. Paciano Masceter. My understanding that Ms. Masceter will be going to a different jail to answer a different case after this.
Okay, so I'm sorry, could you say the gentleman's name again because it glitched every time you did?
It's Paciano, Paciano.
Okay, so Mr. Paciano Masceter, and this is no violent or harassing contact?
That is correct, Your Honor.
And she's, okay, and she's not immediately getting out, is what you're saying?
Yes, Your Honor. It's my understanding she's going on to a different case in an unrelated matter. Mr. Masceter has been very vocal that he wants to have contact with his wife. So the state has no objection to him having contact as long as it's not of a violent or harassing nature.
All right. Anything, Mr. Lynch?
Judge, at this time, I'm going to ask the court accept the recommendation from the state. I have discussed with Ms. Masceter what that entails. Judge, nothing further at this time.
All right. So Ms. Masceter, I'm going to accept your plea of guilty. Counts 2, 3, and 4 will merge. I'll sentence you to 12 months to serve 129 days. Credit for time served. Balance will be suspended as long as you have no new violations of the laws of the state of Georgia and that you have no violent or harassing contact with Paciano Masceter. All right. You can go back with the sheriff's office. All right. We're ready on Wedlo?
Yes, Judge, we're ready to go forward.
All right, this is State of Georgia versus Taj Brandon Wedlo. Mr. Wedlo is before the case on 2024 CR 06670, 06671, and case 2025 CR 00261. Mr. Wedlo, you're before this court on battery, family violence, simple battery, family violence, and a violation of a family violence order. You were on before this court on the 23rd day of June to the plea. You were sentenced to 12 months on probation. You have 8 months and 3 days remaining. Your sentence was not told, but it is alleged that by the probation office that on July 11th, you were arrested for the offenses of criminal trespass and obstruction of an officer in Clayton County. You have failed to provide proof of completing an anger management program, and you are $100 in arrears. You're represented by Attorney Lynch is with you. Mr. Lynch, what do you have on behalf of Mr. Wedlo?
So, Judge, at this time, we're just going to ask to go forward with the hearing and then be heard on sentencing if that does become.
All right. So Mr. William Tipton is representing the state of Georgia. Mr. Darius Austin is representing the probation office. Mr. Austin, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I will, Your Honor.
All right. All right. Mr. Tipton?
Yes, Your Honor. Thank you. Please state your name for the record, sir. Mr. Austin.
Darius Austin.
All right. And Mr. Austin, are you familiar with the case of 2025 CR 00261, 2024 CR 06670, and 2024 CR 6671?
I am, sir.
Okay. Is the defendant named on those cases Mr. Taj Wedlo?
That is correct.
Okay. And are you the probation officer assigned to this case?
I am, sir.
Okay. So you filed a petition for revocation of probation. Is that correct?
That is correct.
Okay. So tell me about that petition. Why did you file that petition?
So I had informed by Ms. Ponder that the defendant was harassing her. She had someone doing her yard work, and she had called complaining that the defendant had been going back and forth in her yard and getting into it with her lawn care provider. And then also she had called me back later that day to inform me that he had indeed walked in front of her door and would not go away. I then informed her of her rights of what she could do, and as the probation officer, that I couldn't do anything at that time until charges had been filed. Once the charges were filed, I received them on July 11th, and I proceeded with the warrant, and therefore a warrant was taken out on the defendant for the new offenses of criminal trespass and obstruction of an officer.
Oh, my phone today. Oh.
Sorry, my apologies. I've got something pinging on here. Let's see. And being the probation officer assigned to this case, you filed in your petition failure to complete an anger management program. Is that correct?
Correct. That was assigned by the courts.
To this date, have you received proof of an anger management program being completed?
No, I have not.
Okay. And is he still in arrears of $100?
That is correct.
Okay. You mentioned that you had contact with Miss Ponder. Can you tell me about who Miss Ponder is?
Ms. Ponder, at the time was the neighbor to his father, Mr. Cedric Wedlo, and she received my information from him.
Okay. And was Miss Ponder's complaint how you became aware of the new violation of criminal law?
That is correct.
Okay. Okay, then. And were there any other technical violations that you're aware of?
No, not at this time.
All right. Thank you, Mr. Austin. I have no further questions at this time.
All right. Thank you.
Just a couple questions. I'm sorry, Judge.
Go ahead. I was just gonna say, ask your questions.
Mr. Austin, prior to you filing this petition, had Mr. Wedlo reported to probation as directed?
He did report one time in the beginning once he was released from jail.
And so he didn't miss any reports other than those that were missed due to him being locked up on the incident that we're here about?
That is correct.
Okay. Had you discussed, well, scratch that. No further questions.
Your Honor, I have one follow-up question.
Go ahead.
Mr. Austin, how soon, well, it's kind of multiple questions that go down one train of thought. Mr. Austin, when was Mr. Wedlo placed on probation?
His original probation was placed on June 23rd of 2025.
Okay. From what you were aware of, when did this violation of probation occur?
July 11th of 2025 in Riverdale, Georgia. Okay.
As a probation officer, using your knowledge, training, and experience as a probation officer, is it normal to get a violation of law that quickly after being placed on probation?
No.
Okay. Based on your knowledge, training, and experience as a probation officer, you consider Mr. Wedlo to return to probation?
No, he is not a good candidate for probation.
Okay. I have no further questions for this witness.
All right.
Nothing further.
Okay. Does the state have any other witnesses to present?
Yes, Your Honor. State has two additional witnesses, both Officer D. Rogers and Officer Lenise Ponder. State's going to call Ms. Ponder.
All right, Ms. Ponder, unmute.
Okay, I am on mute. Can you hear me?
Yes, ma'am. Do you have your video on?
Yes, ma'am.
All right, I see you. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, Mr. Tipton, you're a witness. Ms. Ponder, you can put your hand down. Thank you.
Ms. Ponder. So, Ms. Ponder, you're familiar with Mr. Taj Wedlo, is that correct?
Yes, sir.
Okay, can you give me a little background about how you're familiar with Mr. Wedlo?
I met him through his dad when they first moved next door to me. Just seeing him out, I've always spoken to me and everything else, and his dad made me aware that his situation, and I was speaking with his dad in reference to programs here in Clayton County, which is Riverwood, that he's been trying to get his son into a facility that he have not have registered anything like that of my knowing. So I speak with Mr. Tajay being outside. He asked me can I bring some things back from the store when his dad at work or whatever, which I did do. And after I started noticing him going around my neighborhood, around my house, towards my window, standing in front of my door, being harassing to my lawn care guy on several incidents when people come and do stuff for me, just being an outburst. And then he got arrested back in June, Mr. Tajay, from being harassing. And I have videos of this also of Mr. Tajay, and I told him that's not respectable. When I caught him in front of my door again, he's choose to come back and just stand directly in front of my door. He called the police to my residence and saying that I was deceased in my house, that I was calling his phone. I never knew his phone number. I asked his dad, why did he give him my phone number? I told his dad I wasn't trying to press charges on him when I spoke with him back in April, but Tajay still continued to do harassing things to my residence after he was warned by the Riverdale police to stay off my premises, and he still chooses to do that. At 2 and 3 o'clock in the morning, he'd be out having outbursts saying, bitch, come outside. He'll do something to me. So, that's not my name. So he wasn't talking to me.
Okay, I want to draw your attention specifically to July 11th of 2025. Can you tell me about what occurred on that day, please, ma'am?
Yes, he came in front of my door on several times, walked around my house. He stood directly in front of my door. I have videos of that. So I said, I'm going to call the police. I don't want to call the police on you, Tajay, but I'm going to call the police on you.
Mm-hmm.
I talked to him for a long time. My granddaughter got threatened because she went to the mailbox. That's when he saw somebody come at my house. He came back on my premises several times. I said, you're being very disrespectful to me right now. He said he don't fear the police. So I called his dad and told him, I said, I'm going to have to call the police on your dad, your son, because he said, do what you got to do, Miss Ponder. And that's what I did. And at that time, Riverdale police came, and I said, I'm going to press charges on you this time. And he started fighting with the officer. I have videos of that where they had to handcuff him, his feet in his hands, because he was fighting with the police officer.
Okay, when you say he was fighting with the police officer, could you describe that to me?
When they were trying to bring him out the house.
I got you.
Yes.
But what type, when you say he was fighting, do you mean that he...
physical contact with the police officer when they was asking him to come on out.
Can you describe the physical contact to me?
Tajay was throwing his hands up before they was able to get handcuffs on him, because it took 3 officers, and one of the dark-skinned officers that I gave the water to was actually the one that Tajay had more contact with. And that's when they tased him in the house coming out the door. And that's when they ended up putting handcuffs on his feet also, because they had to put handcuffs on his restraint, his feet, and his hand to get him in the police car.
Okay, so walk me backwards a little bit. That day, you started by saying that he was ringing the doorbell. Is that correct?
No, he was going around my house, standing directly in front of my door. I have a door on my step. He didn't ring my bell. He stood right there in front of my door, walking past my window.
Okay, and then what happened?
And then he stood directly in front of my door. I told my granddaughter to come back in the house because she went to check the mailbox. I said, come back inside the house, and I go check it. But every time somebody come out my house, he would come to on my premises.
Okay, then. So, and then what happened? Walk me through what happened step by step.
And I called the police and I tried to talk to Tajay when he walked past my window again. I said, Tajay, you're being very disrespectful to my premises right now. I tried to talk to him. I said, I don't want to press charges on you. And he said, well, I'm hungry. I even gave him something to eat. I had my granddaughter put a plate outside and I gave him a plate of food. I said, you're being very disrespectful right now. I said, but I'm going to call the police on you and press charges on you. And that's when he said, he don't fear threatening charges of the police.
Okay. So you mentioned that they had to take him out of your house.
No, out of his dad's house. Because every time the police come, he'll run back in the house.
Okay. Okay. So, had you previously told him not to enter onto your property?
Yes, sir. He was filed on criminal in April when I called the police on him.
Okay. Okay.
And it wasn't just me that he was harassing. He harassed several people out in the neighborhood.
I have no further questions at this time, ma'am. Thank you.
Mr. Lynch?
Just a few questions, Ms. Ponder. You described behavior that you witnessed from Mr. Wedlo on July 11th. You also described having spoken to him previous to that, right?
In reference to, repeat that again, I'm sorry.
Let me ask a better question. Prior to July 11th, you had some conversations with Mr. Taj Wedlo standing next to me.
Yes, sir.
And any of those conversations, well, when you have spoke to him, he wasn't always harassing or threatening or confrontational with you, was he?
More, he's always been hyper. I've always had him to ask him to tone the volume down, tone it down. He's very been hyper. And he said he's going to go get some help. And because actually his dad was introduced me that he needs to get some mental help and some other substance abuse help.
Okay.
And yes. And I even gave him some places that his dad said he was very aware of in Clayton County that he's supposed to be dealing with. He was on probation. And that's how I got the probation officer number through his dad. And I said, I don't want to press charges on him. I just want him to get some mental and substance abuse help.
Okay.
Because see, I saw him several times leaving at the house on several occasions. And I do have some evidence in my possession because I do home demolitions that I found in the residence of Mr. Whitlow.
Okay. And so you had discussed with Mr. Wedlo Riverwood as a potential place where he could get treatment for mental health.
I'm sorry. Yes, sir, I did because of the fact that I was told that he was supposed to be going and get some assistance, and he did admit that he was on some drugs because he called the police after I called the police and said he needs some substance abuse help.
And with that, what you just mentioned, those phone calls, to your knowledge, was that on July 11th or are we talking?
Yes, sir, that was July 11th.
Okay. And from your personal observations of Mr. Wedlo on that day, based on your experience, did it seem that he was having mental health struggles at that time?
No, sir. It was more substance abuse issues.
Okay. Could it have been both?
It could have been a mixture of both.
Okay.
But he normally don't act like that. I've seen him when he's on a different level than calm, but you can always tell the difference when he act, because he get more aggressive and he cusses so many people out, even in the neighborhood. When you notice he has substance abuse and both mental and substance abuse.
Okay. And just on July 11th, was that the day, or were you talking about a previous day when you had actually retrieved some items for him at his?
No, this was just recently because like I said, I do demo. I do know the homeowner, and I do clean the property up. He pays me. Yes, sir. And I just, like I said, I cleaned the house up and found some stuff that I kept on my possessions of evidence, and the owner didn't have a problem with me keeping it.
Okay. And then in reference to you relayed an incident where you had provided Mr. Wedlo with something to eat. Was that
Oh,
on
yes.
July 11th?
Yes, it was on July 11th and past. Back in May, I actually went to the store and bought some chips and some lunch meat. I sure have. Yes, sir. I feed anybody.
Okay. Well, thank you, ma'am. No further questions.
Yes, sir.
Your Honor, I have a couple additional questions.
Go ahead, Mr. Tipton.
Thank you. So, Ms. Ponder, you mentioned Riverwood and that you suggested Riverwood and a few different things that Mr. Wedlo could do to get some help. Is that correct?
Yes, I did.
Okay, then. So, how are you aware of these things?
Okay, I worked over 19 years on Fulton County Sheriff Office as a supervisor, and I'm aware of all the drug treatment programs throughout Clayton County, Fulton County, all the jurisdictions here in Georgia. I'm very familiar with those. Yes.
Okay, so walk me through that a little bit more. What are your professional qualifications that would give you a little insight about whether or not someone was on drugs versus mentally ill?
Okay, you can actually tell that they act more assertive and aggressive. With that being said, you can tell from just my experience and seeing them, they're more. You can tolerate them more. They'll listen to you. But actually, I know Mr. Tajay, how he has outbursts and start cussing his dad out early in the morning time. Like I said, I recorded a different, and he's very calm because he even asked me, "Can I help you outside in the yard?" And I asked him, are you okay? How's your day?" And I noticed that, and when he's actually my yard guy comes, anybody come to my house and he has outbursts with them.
Okay. So I want to ask you just super quickly, this will be my last couple questions.
No problem.
So do you have any concerns regarding Mr. Wedlo being released?
I do at the present time because I know that him getting out, he have let me down, and I'm sure his dad also throughout the things that he continued to do, and he have not met any of the Judge Haywood's recommendations and the probation recommendations for him to get help. He gets out and he's turn around and be doing the same thing over. He's not getting help that he's need.
Okay. And I specifically want to ask, do you have any concerns for yourself and your person?
Yes, I do. Yes, I do, because of the fact that I told his dad in reference to that, with him coming, this is the last known address and stuff like that. And I think that Mr. Tajay, with me seeing him leave at 3 or 4 o'clock in the morning when I have different assignments or whatever, I see him leave and come back, and he'd be outside, sitting in his dad, one of his dad vehicles. I don't know what he'd be doing, but to see him, because I'm always looking at my window and seeing him.
Okay. And then let's go a little more broadly. Do you have any concerns regarding the general community?
Yes. I mean, with my community right now, yes, because he had gotten to it with so many people out here, and he's not getting no help for himself that he needs.
Okay. So based on your knowledge and just your knowledge, are you aware of Mr. Wedlo getting any type of help?
He has not got any help. Based on me and his dad conversation, he has not reported anywhere trying to get any help. I even told his dad I would be willing to call around for him, since he said he worked in the daytime. I was willing to call to find some facilities here, because I know Clayton County is limited to some of their drug facilities, to get him help. But he kept harassing me. So at this point now, I don't feel comfortable with him.
Okay. I have no further questions. Thank you, ma'am.
Yes, sir.
Mr. Lynch, anything else?
No, thank you, Ms. Ponder.
Okay, Ms. Ponder, you're free to go at this time. If you wish to stay, just mute your device, all right?
Yes, ma'am.
All right. Does they have another witness to call?
Yes, Your Honor. Officer D. Rogers. Officer Rogers with Riverdale PD, please turn your camera on, turn your volume on, and raise your right hand.
I'm gonna need Officer Rogers to pull over.
I'm getting ready to now. That's what I was just getting ready to say. I gotta safely pull to the side here just for a minute.
Thank you.
And thank you for coming on, Officer Rogers. I know you're busy and on duty.
No problem. I appreciate y'all's patience.
No problem.
Okay.
All right,
Sorry, about that, Your Honor.
no problem. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Mr. Tipton?
Yes. Officer Rogers, I want to draw your attention to July 11th of 2025. First off, how are you employed, sir?
Work as a officer for the City of Riverdale Police Department.
And being a police officer for Riverdale, are you post certified?
Yes.
And being post certified, are you authorized to investigate crimes, issue citations, and make arrests based on your investigations?
That's correct.
All right, thank you. So I want to draw your attention to July 11th of 2025. Were you working on this date?
Yes.
Okay. Did you have occasion to go to 810 Pixley Drive in Riverdale, Georgia?
Yes.
Okay. Why did you go there, sir?
So there was a disturbance situation going on that my partner, Officer Hernandez, initially was the officer responding out there to, and he requested backup. So I went out there, and he informed me that this particular subject, Mr. Wedlo, did like to fight and physically resist officers. So he told me we were gonna have to fight with him, being that that's what his aggressive behavior was and his manners were. So he told me that he had, trespassed onto Miss Ponder's property, and he had already been criminally trespassed before and everything. So the decision that was made was that he wanted to place Mr. Wedlow under arrest. So that's what we proceeded onto the residence of 810 Pixley Drive to do.
Okay. Did it go smoothly? Did putting Mr. Wedlow under arrest, did that go smoothly or no?
No, it did. It did not. It went completely opposite of how I thought it would have went. But that involved us, attempting to make contact. We knocked at the door. We spoke with the father initially at the door. Mr. Wedlow was kind of like, back a little bit from the door. So we were talking to him. Officer Hernandez was, talking to him, letting him know like, hey, come on, he's basically placing him under arrest, wanting to take him to jail and stuff like that. He started outbursting, I'm not going to jail. Y'all not finna take me, this, that, and the third, basically telling us he's not going. So after a brief moment of being at the door, doing that, the dad steps to the side, allowing us to come in, and he balled his fist up and he was just standing there like that's an aggressive posture towards us. So we went to proceed to try to go ahead and place him under arrest. He pushes away from us and runs down the hallway, and then when he runs down the hallway, I immediately, like I said, or I don't know if you read the report, but immediately, I had took my taser out and I turned it on because I'm not sure if he has any weapons or he's trying to get to anything. So we're trying to prevent that. He stops, he turns around, charges back at me. I put the taser away and grabbed him. He still tried to charge past me and push, Officer Hernandez. And then at that point, I was able to get my taser back out and successfully deploy it. And we were able to get him down to the ground. And after moments of struggling and fighting with him, we were able to get him in handcuffs, and he was still throwing himself around and just flailing his body, trying to stop us from getting him safely outside and into the car.
All right. So I actually have the report, and you mentioned in the report that you had to perform what's called a dry stun. Can you tell me what a dry stun is?
So what that is after the prongs from the taser are deployed, a dry stun involves me bringing the taser close to his body, placing it on his person, and then arcing the taser that way. to achieve his muscles locking up so we can get the handcuffs safely on him, because he was still physically resisting, pulling his hands away from us, saying he's not giving up, he's not going to give us his hands. And yeah.
Okay, and to do a dry stun, you have to be right up on someone. Is that right?
Yes.
Okay. Was he still struggling while you were right up on him?
Yes, he was. He was turning. He was not trying to give us his hands after receiving multiple commands to give us your hands. And he still refused to do so. He tucked his hands inside and would not give his hand up.
And once you placed him under arrest, did it continue? Can you walk me through what happened between getting him in the car and getting him booked into the jail?
So once we got him in handcuffs and everything, finally, we got him up and started to take him out of the house. He still was trying to grab and hold on and throw his body in weird ways to prevent us from safely getting him out. Once we finally did get him out, we were trying to get him into the car. He's dropping his body. He's not trying to get up. He's just basically dead weighting himself, so we can't get him into the car. He was kicking, so we got the leg shackles to put on him so we could limit that. And we finally got him in the car. During the course of all of that, fighting with him and doing all of that, I did injure my right ankle in the process from dealing with him doing that. We got him into the back of Officer Hernandez's car and transported him to the jail on what they call a rush or a ramp call, just letting them know that, hey, we have a combative subject or, an aggressive subject that we're bringing into the jail, just, giving them a heads up.
Okay. What was Mr. Wedlo charged with on the 11th?
As far as I know, the criminal trespass, and I'm not sure if criminal trespass, obstruction ×2, for me and Officer Hernandez, and I'm not sure if he charged him with assault or not for kicking and all of that stuff there.
Okay. Are you familiar if that? Are you aware if that was misdemeanor or felony obstruction?
I believe he put it as misdemeanor obstruction. I'm not sure how he did it.
Okay. Thank you, officer. I have no further questions at this time.
Okay.
Officer Rogers, was your investigation captured on your body cam?
Yes, my body cam was active on that day.
And based on your training and experience as a law enforcement officer, did it seem to you that Mr. Wedlo was having mental health struggles at that time?
To me, I didn't recognize anything right off the bat that, screamed out front that it was a mental episode or a mental breakdown or anything. No, that wasn't nothing, to stand out at that particular time. But I was, like I said, advised by my partner that he did like to fight officers and there was an issue with mental illness with him, his history. That's all I was made aware of because that was my first time having to deal with him in that manner.
Okay. No further questions.
No further questions from the state, Your Honor. State rests at this time.
All right. May this officer be excused?
Yes, Your Honor.
All right. Thank you, sir. Be safe.
No problem. Thank you.
Thank you,
All
sir.
right. Does the defense have any witnesses to present on behalf of Mr. Wedlo?
Judge, I don't believe so. Could I just have one moment to talk to Mr. briefly?
All right. Mute your device.
Your Honor.
Yes, Mr. Lynch?
Judge, I have advised Mr. Wedlow about his right to remain silent in this case, and I have specifically advised that he exercise that right due to the pending charge, which may be a felony. However, Mr. Wedlow does wish to address the court, and I'm not, and so that's where we are, Judge.
All right, Mr. Wedlow, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am, Your Honor.
All right, put your hand down. You've spoken to your attorney about your constitutional rights to remain silent, correct?
Yes, ma'am, Your Honor.
And your attorney has shared his advice about you, whether you should or should not testify. Is that correct?
Yes, ma'am, Your Honor.
All right. Do you understand that nobody can make you testify or promise you anything to get you to testify?
Yes, ma'am, Your Honor.
Okay, and you understand that you have the right to remain silent and that anything that you say can be held against you by this court or by the prosecutor or anyone else who listens to this hearing.
Yes, ma'am, Your Honor.
All right, and you still want to testify?
Yes, ma'am, Your Honor.
All right, so I'll find that your testimony is willingly and voluntarily given. Go ahead, sir.
And Your Honor, I want to confirm.
All right, hold on, Mr. Lynch. What was it, Mr. Lynch?
Actually, Your Honor, I'm just going to let him say what he feels he needs to say, and then I may have one question for him at the end of that.
All right, Mr. Tipton, did you have a question?
Yes, I just want to confirm that this is being taken down and on the record.
I'm recording it, and we do have a court reporter present.
Thank you, Your Honor.
All right, Mr. Wedlow.
Yes, ma'am, Your Honor. How you doing? Thank you. I would like to say, first and foremost, I am paranoid schizophrenic, and I do have a substance problem, and I reached out to the jail about it. Also, fact, I have not, in terms of these allegations, committed these charges as well. Simple fact being that I actually was going through something when the police came, because they just came and offered a verbal warning first. Then they came back 5 minutes later. So I'm in a state of shock and awe, wondering what's going on and why are they coming in the house. I actually did not resist in a aggressive manner, because I'm feeling it's unlawful, it's wrongful and unlawful, especially how I was treated during the process of being detained. I was actually, I have lacerations on my body from being tased, and actually know for a fact that the right, my privacy right, and most foremost, if she even has the messages I sent her, it's all about me being not a nurturer. What's it called? I'm overprotective of women, because I have no idea what goes on around me, especially with suspicions and everything of that nature. So what was going on with that, I can't lie. The officers told me to stay away. Yes, sir. But when I seen that day was an opportunity to apologize, and I seen that it wasn't illegal. I was doing some research. Was it illegal to apologize to someone? And when she was responding, when she gave me the plate, I'm thinking everything's okay. That's then the police came afterwards. So I wasn't fighting the police. I was actually trying to figure out what's going on. Like, you just came and said a wrongful arrest. I mean, you just came and said, I'm issuing a verbal warning. Then 5 minutes later, come back and say, oh, we have to take him to jail. Now we have to take him to jail. So that's just a portion of what I really wanted to say, because I'm kind of not frantic, but jittery right now because I don't want to disrespect the court in any way, or
Yeah, about that. Yeah, because they like, I don't know. I think they gotta come out and give me the paperwork.
Mr. Cedric Wedlow, you're not
I
muted,
muted him.
sir.
Go on.
Okay. And I just everything to be resolved because this is not what I wanted. When I took my plea to handle business how it was supposed to be handled, this is not what I wanted. I made the mistake. Yeah, but I feel like these charges are false accusations because of the situations, how they went and how they portrayed in the circumstance. Like I'm not how someone can be warned and then automatically, and I didn't say, I was just like, I just was verbally assertive, but I wasn't physically trying to resist, because I'm not known for resist fighting officers, whatever. Any of the times I've been arrested, and it's been a few, I've never fought officers or anything of that nature. Your Honor, sorry, man. I should have asked how you was doing. That's what I wanted to do first. Ask you how you was doing today.
I'm fine, Mr. Wedlow. I'm sorry to see you before me again, but I'm fine. What's going on?
Yeah, I just wanted, because I'm not an offender. I made a mistake, but I'm not an offender, and I just wanted to be known, like I wasn't coming at Miss Ponder in any sort of way. I hope she can forgive me if she took it in a negative, because I texted her and I told her like who I am and what I'm about, and I'm overprotective of women, like because I grew up a certain way. I don't want a pity party, but it's just I feel like if y'all would just help me, if I know it that I thank you.
Mr. Lynch?
Just Mr. Wedlow, are you willing to, if an opportunity was provided, are you willing to enroll in counseling or seek treatment for mental health issues?
Right now.
Okay. That's the only question I have at this point, Judge.
Okay. All right. Any other questions from the state, or any questions from the state for Mr. Wedlow?
Nice. Can I say one more thing too, Your Honor, Mel?
Yes, Mr. Wedlow.
Thank you. For the probation aspect of it, I forgot. He said a date, and I know it was the 25th, and he talked to my father, and I was fearful because I didn't know what was going on. So I should have just came to him, seek guidance from him, like I was asked to. Yeah. So yes, that's it.
Okay. Mr. Tipton, did you have any questions?
No questions, Your Honor. I think the court's heard enough.
All right. Does the defense have additional witnesses or evidence to present before the court?
No, Your Honor.
All right. Argument?
State will reserve, Your Honor.
Mr. Lynch?
Judge, I just wish to be heard on sentencing, Judge.
Go ahead. I don't even know what the recommendation is, so y'all tell me.
Your Honor, given this time and the statements that we heard, he currently has 7 months and 20 days remaining on probation, and that was taken away from the 90 days that he was originally supposed to serve on this sentence. So at this time, we are requesting that the 7 months and 20 days be revoked and this case closed.
All right, Mr. Lynch.
Judge, so I'm inclined to ask for them, but I believe it's going to sentence as you feel is appropriate based on the facts that you've heard. So what I would ask the court to consider is that if we are able to get Mr. Wedlo signed up for any kind of mental health treatment, whether that be inpatient or anything that would be appropriate to his situation, that the court would entertain a modification of the sentence to allow him to do that. If I can, if myself and any other resources that can be brought to bear can make that happen for Mr. Wedlo.
All right, what's the state's position on this hearing?
Your Honor, state's going to request that the balance be revoked. We've heard on this through this hearing that the victim in the new case is currently scared of Mr. Wedlo, that Mr. and make contact with Mr. Wedlow's new charges, and the officer wasn't 100% familiar with it, but his new charges are actually felony obstruction. Based on the contact he had with the police officers. Mr. Wedlo said that he knew he wasn't supposed to go back there, but he still went back there. He said he only went back there to apologize because he didn't think it'd be illegal to apologize, but he still went someplace he shouldn't have. And my fear, Your Honor, is that in trying to do maybe self-help or to make some kind of movement in his life, he's going to end up hurting someone. And I don't think that it is in the community's interest at this time to give Mr. Wedlo any more chances at probation. The victim in the new case informed us that she's informed him about the help that he could get, and he hasn't taken it. Mr. Austin has informed us that that Mr. Wedlo has not taken the anger management class, even though that would have helped him as well. The only thing that I think that I can agree with Mr. Wedlo at this point is that he made a mistake, but I'm concerned that that mistake is going to cause Miss Ponder or someone else in the community serious harm. And for that reason, the state's going to ask for the balance to be revoked and case determined upon completion of that time.
All right, Mr. Lynch.
So Judge, my request to the court still stands, and obviously that would be subject to the court's approval. I would ask that that be placed in the order. Judge, I would point out that he did have not too much time on probation before the new arrest, and that he had reported as directed. Judge, he has expressed to me willingness to go to Riverwood. I know that there were discussions with his father about making that happen. I believe prior to his arrest, but certainly since the arrest. Judge, mental health issues, they don't just go away no matter what is ordered. And unfortunately, in a situation where someone is not getting the appropriate treatment, they can't necessarily predict when these issues are going to happen. I don't think it's really in dispute whether Mr. Wedlo has serious mental health issues, whether that's complicated by substance abuse or not. It is still something that would benefit the community from him getting a hold of that. And so I just am asking the court to, with whatever sentence, assuming you're finding that he violated his probation, whatever sentence you give, you either place in the order that it can be modified, or you at least entertain a modification if I can get him into a program.
All right, after a hearing where both sides presented witness testimony, the court finds that defendant has violated his probation by committing new offenses, by having aggressive and harassing conduct with a neighbor, and by failing to take classes ordered by the court. Defendant shall have the balance revoked and shall serve day for day due to the number of individuals who have expressed fear of the defendant. I'm sending it over.
Thank you, Your Honor.
Thank you, Your Honor.
And does the court take a position on whether you would entertain that modification that was requested?
If he has a modification that requires him to serve in an inpatient program that lasts longer than the sentence, I will entertain that modification, but it has to be inpatient. Not Mr. Wedlo can't be walking around. There are too many people who have expressed concern about his behavior and his repeated behavior. All right, so I believe that is our last case we have on this calendar. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.